Mr. President, I rise today to speak about the nomination of Senator Sessions to be the next Attorney General. I believe one of the most important jobs of a U.S. Attorney General is to protect the people's right to vote. In the tumultuous days of the early 1960s, on a hot afternoon, I watched on a grainy black and white TV as Dr. King delivered his memorable "I Have a Dream" speech on the steps of the Lincoln Memorial. His soaring, spiritually laced speech challenged us to commit our lives to ensuring that the promises of American democracy were available not just for the privileged few, but for all of God's children, black men, white men, Jews and Gentiles, Protestants and Catholics. That was his quote. Now's the time, Dr. King urged, to make real the promises of democracy. He stressed that a central promise made to the citizens in a democracy is the right to vote and to have that vote counted. We cannot, he said, be satisfied as long as a Negro in Mississippi cannot vote and a Negro in New York believes he has nothing for which to vote. End of quotation. Half a century has passed and our country has changed with the times. But one thing has not changed: the right to vote for all God's children in America is still under assault. Unbelievably, we are not so very far from the problems of 1963. Despite the passage of time and landmark civil and voting rights legislation, 5 decades later, there is still considerable voter suppression in this country. In fact, several states have recently enacted restrictive laws cutting back voting hours on nights and on weekends, eliminating same-day registration, and basically making it harder for people to vote. Standing in between a citizen and the voting booth is a direct contradiction to the vision of equality put forth by our founding fathers. Because back then in 1776, they declared that all men were created equal, but many in our country had to wait another 94 years before the 15th Amendment to the Constitution granted citizens the right to vote, though not all citizens. Ratified in 1870, the amendment states, "The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. The Congress shall have the power to enforce this article by appropriate legislation." And that's the end of a quote of our Constitution. And still, it took another 50 years before women in America were allowed to vote. After her arrest for casting a ballot in the presidential election of 1872, Susan B. Anthony delivered a number of speeches in upstate New York on women's suffrage. And in those speeches, she noted that the right of all citizens to vote in elections is a key to a functioning democracy. Specifically, one line from her speech stands out. And I quote her. And it is downright mockery to talk to women of their enjoyment of the blessings of liberty when they are denied the use of the only means of securing them by providing the Democratic Republican government the ballot. That's her quote. And after the 19th Amendment granting women the ballot, then it took another 45 years before our nation belatedly enacted the Voting Rights Act of 1965, intended to guarantee every U.S. citizen the right to vote. But does this principle really hold true in practice? The continued voter suppression of which I speak may not be as blatant as it once was, with Jim Crow laws and poll taxes and literacy tests, but it's still very much with us. In recent years, it is obvious that hurdles have once again been placed between the voting booth and the young and minority voters. A devastating blow was dealt by the U.S. Supreme Court when it gutted the Voting Rights Act in 2013. Our nation's highest court struck down a central provision of the law that was used to guarantee fair elections in this country since the mid-1960s, and that includes guaranteed the elections in my state of Florida since that time. Congress passed the Voting Rights Act of '65 to protect our right to vote. It required states with a history of voter suppression to get federal approval before changing their voting laws. And for nearly 5 decades, the states had to prove to the Department of Justice why a change was necessary and demonstrate how that change would not harm voters. But in a 5-4 decision, the court declared in part that part of the law was outdated. It essentially rendered a key part of the law void until a bitterly partisan and gridlocked Congress can at some future time come up with a new formula for determining which states and localities need advance approval to amend their right to vote laws. The majority justified its ruling in the court by pointing out that we no longer have the blatant voter suppression tactics once used to disenfranchise targeted voters across the country. And I so vigorously disagree, because by removing much needed voter protections, it also prevents the federal government from trying to block discriminatory state laws before they go into effect. In essence, states and local jurisdictions are now legally free to do as they please. In fact, just moments after the decision, the Texas Attorney General said his state would begin immediately, was his word, honoring local legislation that a federal court had imposed strict and unforgiving burdens on many Texans attempting to cast a ballot. As has been noted, the right to vote was not always given to all American adults, but our laws adjusted as we became more mature and a tolerant democracy. But the reverse is what has been happening in America today, and especially in Florida. Since the 2010 election, in addition to cutting back on early voting, North Carolina, Ohio, Wisconsin, and Florida have approved voting restrictions that, according to some experts, are targeted directly at reducing turnout among young, low-income, and minority voters that traditionally support Democrats. One study by the Brennan Center for Justice at New York University School of Law reviewed the crop of similar disenfranchisement laws that were enacted after the 2010 decision. All told, the center found that many as 5 million Americans could be adversely affected by these voting laws. And there is a clear political impact as a result of these disenfranchisement laws. 2 University of Massachusetts professors conducted a study that found that there was a clear pattern associated with the voter restrictions in the various states. According to Keith Bentel and Aaron O'Brien, states were more likely to pass limits on voting that those same states elected Republican governors. Those states that increased their share of Republican lawmakers, and those states that became more electorally competitive under Republicans. In 2011, the Florida legislature and state officials reduced a number of early voting days. They reduced them from 2 weeks down to 8 days, including, very conveniently, canceling the Sunday right before the Tuesday election, a day that had historically seen heavy African American and Hispanic voting. State officials countered that registered voters would still have the same number of hours and that they could still vote early, only in 8 days instead of 2 weeks. Well, it didn't work out that way. And Florida also made voting harder for people who had been recently moved to another county and had an address change, such as college students. After it subjected voter registration groups to penalties and fines for mistakes, voter registration, mind you, penalties and fines if you didn't turn it in within a certain number of hours. It was so burdensome that the League of Women Voters challenged the provision in court, federal court, and they won. But not before Jill Cicerelli, a Florida teacher, had helped her students pre-register to vote and ended up facing legal troubles as the result of her well-intentioned public service. A school teacher teaching a government class, getting her kids pre-registered so when they became 18, they could vote, and she got in trouble with the state of Florida. The New Smyrna Beach High School civics teacher unwillingly ran afoul of the state's new convoluted election law. Cicerelli, it turned out, hadn't registered with the state before beginning the drive and didn't submit the forms to the elections office within that short number of hours. Quote, "You're talking about a high-energy teacher who cares about her kids, cares about her community, and cares about her country," end of quote, is how the New Smyrna High School principal, Jim Tager, described his teacher. Thankfully, the Voting Rights Act allowed the federal government to go before a panel of Washington, D.C. judges who found that Florida's 2011 reduction of early voting, which I have just chronicled, here's what the court said, quote, would make it materially more difficult for some minority voters to cast a ballot, end of quote. As a result, Florida had to restore its hours of early voting. And even with these added protections, even with that, the next election, 2012, it was a fiasco. Lines outside the polling places were prohibitively long, with some people waiting up to 8 hours to cast their vote. Now, I'm not kidding the Senate. There were lines in Dade County, Miami-Dade County, 7 and 8 hours. And by the way, some of those lines, there wasn't a nearby bathroom. Faced with calls for extending poll hours, the governor of Florida failed to do what his two Republican gubernatorial predecessors had done: extend voting hours in some of the most swamped polling places to give folks enough time to exercise their right to vote. In fact, a Massachusetts Institute of Technology analysis found that in 2012, Florida had the nation's longest waiting lines to vote at an average statewide of 45 minutes. And more than 200,000 voters in Florida gave up in frustration because 200,000 voters gave up in frustration because the lines were so long. They didn't vote that year. And according to another analysis by Ohio State University and the Orlando Sentinel, they're the ones that came up with that 200,000 figure. And they aren't done yet. As of the 2011 restrictions, as if they were not enough, an elections official in Miami-Dade County in 2012 said that restrooms would be closed to voters at polling sites in private buildings over a handicap access dispute, even though there were bathrooms in those private buildings where the polling place was. The state's top election official in 2012 also told one of our 67 local election supervisors, told her not to allow voters to submit absentee ballots at remote drop-off sites. She, by the way, is a Republican supervisor of elections. She told the State Department Division of Elections to kiss off, that she was running the elections and she was going to make sure that there were enough places around that county where if they had an absentee ballot, that it was going to be convenient for them to go and drop off that absentee ballot and having to take it miles and miles to one place that the Division of Elections at the state level was telling them to go to. That supervisor of elections knew what she had to do to make it easy for voters to vote. And she stuck to her guns. And at the same time, that same Division of Elections in the Department of State denied a request from the city of Gainesville in a municipal election. They denied the request to use the University of Florida campus building for early voting, a move that was viewed by some, more than some, as an assault on student voting by making it more difficult for students to find a place to vote. By then, I had asked the U.S. Attorney General, Eric Holder, for an investigation into the changes in Florida's voting law. And in response, the Attorney General wrote to warn the governor of Florida that the Justice Department would be, quote, carefully monitoring, end of quote, Florida's elections. Quote, during your tenure, your state has repeatedly added barriers to voting and restricted access to the polls, the Attorney General wrote. Whenever warranted by the facts and the law, we will not hesitate to use all tools and legal authorities at our disposal to fight against racial discrimination, to stand against disenfranchisement, and to safeguard the right of every eligible American to cast a ballot. End of quote. Mr. President, I ask unanimous consent that the letter from the U.S. Attorney General to the Governor of Florida dated July 21st, 2014 be entered in the record.
Without objection.
The Attorney General cited problematic actions of the governor's chief elections official, including purging from the voter rolls suspected non-citizens, a move that eventually was blocked after outright opposition from county election supervisors. So in light of this evidence and following a widespread public outcry, what do we do now? Mr. President, as we say, it may not be as obvious as poll taxes and all the other blockades to voting as we've seen in the past, particularly back all of the marches and so forth during the 1960s civil rights era. Might not be as obvious, but there are all these subtle attempts. So what do? I submit that though the problem is complex, the answer is relatively simple. As Americans who cherish the right to vote, we must turn to those schemers and say, there is a promise of democracy that we will not allow you to break. We have an obligation to keep this promise of democracy for our children. Congress may be dysfunctional, but we must continue to push lawmakers for a fix to the Voting Rights Act that the Supreme Court struck down on a 5-4 vote, a key provision. We ought to be making it easier to vote, not harder. I believe no one should have to wait more than 1/2 hour to vote. So I joined with others a few years ago to introduce a bill in Congress aimed at making that standard 30-minute wait time based on the January 2014 recommendation of a bipartisan presidential commission on elections. Keep in mind what President Johnson said a half-century ago. Quote, "The vote is the most powerful instrument ever devised by man for breaking down injustice and destroying the terrible walls which imprison men because they are different from other men." And also remember what Dr. King said. "So long as I do not firmly and irrevocably possess the right to vote, I do not possess myself. I cannot make up my mind. It is made up for me. I cannot live as a democratic citizen, observing the laws I have helped to enact. I can only submit to the edict of others." End of quote. Don't we owe to all our children the right to possess themselves if this is to be a truly free and fair democracy? I believe that two of the most fundamental rights in our democracy are the right to vote and the right to know who you are voting for, and the right to have the confidence that that vote is going to be counted as you intended. Now, if that were not enough, and just as concerning as the ongoing efforts to suppress certain votes in this country is, it's also the amount of undisclosed and unlimited money that is sloshing around in our campaigns. The Supreme Court's 2010 decision in Citizens United has opened the floodgates and allowed the wealthiest Americans to spend unlimited amounts of money to influence our elections. Allowing such unlimited, undisclosed money into our political system is corrupting our democracy. I have strongly supported several pieces of legislation, such as the Disclose Act, to require groups that spend more than $10,000 on campaign-related matters to identify themselves. Tell the people who is given the money by filing a disclosure report with the Federal Elections Commission. But that's not what the Supreme Court decision required. The American people have a right to know who they're voting for, not just the name on the ballot, but who is behind that name on the ballot. The Supreme Court itself said that, quote, transparency enables the electorate to make informed decisions and give proper weight to different speakers and messages, end of quote. And I believe we, as a Congress, have a moral obligation to correct what has happened to our system and to ensure that our voters have the information they need to make an informed decision on Election Day. So this senator has spoken on two subject areas: the right to vote and the amount of undetectable, unannounced, undisclosed, and unlimited money in our elections. For this and many other reasons that I have stated and have not stated, Mr. President, the reasons mentioned in these remarks, I will vote no on the confirmation for Attorney General.